Employee documents have several benefits and should not be taken lightly by employers or employees alike. It encompasses legal requirements and formal documentation that clearly communicates to your employees the expectations on both sides of the relationship. It also provides both parties with a paper trail of important matters covered before, during, and after the employment period.
An employee handbook is an important communication tool between you and your employees. A well-written handbook sets forth your expectations for your employees and describes what they can expect from your company. It also should describe your legal obligations as an employer and your employee rights. There are many elements to an effective employee handbook, but we are going to start off with non-disclosure agreements. Non-disclosure agreements are not legally required. Having employees sign non-disclosure agreements and conflicts of interest statements helps to protect your trade secrets and company proprietary information. Anti-discrimination policies. As a business owner, you must comply with the Equal Employment Opportunity laws prohibiting discrimination and harassment. Employee handbooks should include a section about these laws and how your employees are expected to comply. Compensation clearly explains to your employees that your company will make required deductions for federal and state taxes, as well as voluntary deductions for the company's benefit programs. Work schedules. Business owners should describe your company's policies regarding work hours and schedules, attendance, punctuality, and reporting absences, along with guidelines for flexible schedules. Standards of conduct are to document your expectations of how you want your employees to conduct themselves, including dress code and ethics. General employee information. Your employee handbook should include general employee information, which is an overview of your business and general employment policies covering employment eligibility, job classifications, employee referrals, employee records, job postings, probationary period, termination and resignation procedures, transfers and relocation, and union information if applicable. Safety and security is used to describe your company's policy for creating a safe and secure workplace, including compliance with occupational safety and health administration's laws that require employees to report all accidents, injuries, potential safety hazards, safety suggestions, and health and safety related issues to management. When dealing with employee benefits, make sure to detail any benefit programs and eligibility requirements, including all benefits that may be required by law. Leave policy. Your company's leave policy should be carefully documented, especially those you are required to provide by law. Family medical leave, jury duty, military leave, and time off for court cases and voting should all be documented to comply with state and local laws. These are the basic topics inserted into an employee handbook, although any information a business owner wants to put into a handbook can be put in.
When managing a company, one of the most important things that need to be done is producing and managing fair, accurate, and non-biased documentation of employee behavior and performance. Managers and supervisors should know that something as little as writing a handwritten note is creating potential litigations that could end up with consequences later on down the road. Companies with good documentation from supervisors and managers means a lot when it comes down to them winning or losing an employment-related lawsuit. Some forms of discrimination can be based on sex, age, religion, disability, national origin, or race. Making good documentation of your current employee's pattern of poor work performance and discipline can prove that the employee's firing wasn't related to discrimination. An employer will have a much harder time trying to prove them wrong without any documentation. Another thing about making good documentation is that it makes employment-related claims less of a headache when trying to find files. The EEOC, better known as the Equal Employment Opportunity Commission, as well as other federal and state agencies that enforce employment laws, will often ask employers during the investigation to show some type of documentation of performance issues related to the employee that filed the charge and other employees who are going through the same or similar issues. Like I said earlier, having good documentation on file will make everything a lot easier for the business to defend. Years ago, they had something called document retention, which meant maintaining the proper printed materials that could possibly be needed in case of lawsuit or charge files with the government agency. Nowadays, businesses have to deal with not only paper documents, but emails as well. These documents can be easily accessed and located in places that you wouldn't even think about, such as your supervisor or manager's cell phone. Employee performance evaluation and progressive discipline are tools that all supervisors and managers should use in order to motivate employees, set employee goals, and correct the behavior of an employee. Most employers do written performance evaluation annually and sometimes semi-annually if needed. Even though this is done, all companies should think about having random performance evaluation just in case changes may happen within the employee's performance of duties.
The purpose of an independent contractor agreement is to describe what the contractor is expected to do. There is an important distinction here between employer and independent contractor. In an employee situation, you would describe in detail how you want the employee to perform the job. In an independent contractor situation, you would only describe the results you are expecting, not how to do it. With that said, it is perfectly okay to specify in great deal what end results the independent contractors are expected to achieve. It's strongly advised to look at samples available online and in academic articles and books on Western's library website to further understand how to communicate what results you are looking for when hiring an independent contractor. In the title of the independent contractor agreement, never put the words employee or employer because that is not what the independent contractor is or what the firm is to the IC. It is advised to use the full name or corporate name of the independent contractor. Later throughout the document, you can refer to the independent contractor's name as an abbreviated version or just simply use the word contractor instead. The same can be said about the person or corporation issuing the contractor agreement. An abbreviated corporate name or just simply client or firm can be used. In many industries, it is common that independent contractors receive payment by the hours they work. In some cases, it may be a good idea to place a cap on the amount to be paid to a contractor so they do not take advantage of this by hourly basis. The alternative payment form to this is using a fixed amount. The next step with payments is to determine if you want to pay the IC work upon completion, divide the pay amounts at separate times, or pay based on installments. Installments are a good option when the ICs are working on a very long project that would make using a fixed payment plan seem unreasonable. It is not necessary or advised to give ICs the devices, tools, or any kind of materials they may need to complete the job assigned, as this would be an indicator that the IC is being treated as an employee rather than an independent contractor. What a firm can give an IC is a leasing contract or providing the IC with office space. The IC should be charged as any outsider to the firm would, further adding to the foundation that this is an independent contractor, as any firm's employee would have access to these materials for free. Terms of agreement are not only important to determine if the job of the IC is done, but to have guidelines in place in case the IC does not meet the results wanted by the firm. If an IC is not working according to the timeline mapped out and agreed upon, the IC can be terminated for reasonable cause. Terminating the IC with a notice is also an option, or suppose there is a change of plans in the project the firm had in agreement with the IC. The firm can modify the contract also with alerting the IC the firm is doing so. Some give and take may be involved to reach a new agreement, but no contract has to be 100% set in stone. And these are just a few aspects in a very loose outline of an IC agreement, and there is the potential to go extremely in-depth with understanding this document and all the possible clauses. If you are interested in a sample form, there's one available through WCU's EBSCO host titled Independent Contractor Agreement Favorable to the Independent Contractor. It is a sample that has blank spaces to allow anyone to personalize the document to their liking. With any of this information, I do not claim to be giving legal advice, as I'm not a lawyer, and would encourage anyone serious about this content to seek a licensed attorney.
The Form I-9 is a product of the Immigration Reform and Control Act passed in 1986. This form is used to verify the authorization of employees to earn wages in America. Employers are required to file an I-9 for every employee working in the United States regardless of their background. They are also required to hold every employee's I-9 for 3 years after hire or 1 year after termination, whichever is later. But the good news is, it's free and only 2 pages long. According to the Department of Homeland Security estimates, there are roughly 11.4 million unauthorized immigrants in the United States, and they make up 5.1% of the workforce. Most Americans would assume a large majority of these immigrants have crossed our southern border. However, they only make up about half of the illegal population. The other half are mostly comprised of those who overstay their visa and therefore could be from any region. This is important to consider because knowing the legal status of your current and potential employees is crucial for staying out of trouble with the feds. The Immigration and Customs Enforcement Agency inspection process can be lengthy, but offers plenty of warning and ample time to fix any employment problems within your organization. They allow a business 3 days to provide all of their employees I-9s after notification of an upcoming inspection. Thereafter, a business has 10 days to rectify inadequate records if the inspection reveals any records or employment violations. Typically, notifications and warnings are sent out before penalties and fines are issued. Otherwise, fines will be assessed based on the severity of the violations and the company's failure to comply. A business that knowingly violates employment law is subject to fines up to $16,000 per violation and possible criminal prosecution. Between 2009 and 2012, the Immigration and Customs Enforcement Agency collected over $80 million from these violations, and the fines have only increased since 2012. And I'll conclude with a couple of examples of these fines levied for employing illegals. Grand American Hotels and Resorts was recently fined nearly $2 million, and Abercrombie & Fitch was also fined over $1 million for similar violations.
Hiring is a mostly straightforward process, with individuals often entering an at-will status of employment with a firm. However, it sometimes makes sense to complete an employee contract in order to preserve certain traits of the professional relationship between employers and employees. As with most aspects of life, there are pros and cons to this situation, so let's take a look at some of the positive facets of employee contracts. They make sense when trying to retain key employees for a specific time. It can become costly to hire and train someone, only to lose them after the process is complete. Many times, contracts ensure that these individuals must give several days' notice before leaving a company. The time period is typically 60 to 90 days. You can also use contracts to beef up an offer should you want to sweeten the pot for potential key individuals. For instance, bonuses and stock options can be encompassed in the contract. It could also include information about special perks employees would forfeit should they leave the company early, such as valuable severance package. Contracts can also serve to protect company secrets, an aspect that is especially important with high-tech firms. They can prevent employees from revealing secrets, working for the competition, or even soliciting customers. It is important to note that these non-competing contracts can be difficult to uphold in court, so you must be thorough when drafting them. The more reasonable the contracts, the more likely success will be. For example, employers can't prevent an individual from never working for a competing firm. However, they could possibly stop them from working for competition within a 30-mile radius of the company for up to 2 years. At-will contracts preserve the employer's rights to fire an employee whenever they see fit, as well as preserve the employee's rights to quit at will for any reason within the law. There are a few disadvantages to these contracts, such as should an employer ever have a need to terminate an employee that is not working out, the contract could stand in the way of that process. Typically, the agreement is termination for cause, unless the contract term has ended. If you ever find yourself in litigation over an employee contract, the courts could question the cause. For this reason, it's important to pay special attention to the termination portion. There is another type of contracts that has warranted attention in the past decades, and that is contracts of a psychological nature. These contracts are based upon an individual's belief regarding reciprocal obligations. According to studies, beliefs become contractual when the individual believes he or she owes their employer certain contributions, such as hard work and loyalty, in return for certain inducements, like high pay or job security. Contracts are useful tools that provide a safety net for employees and employers who enter a professional relationship by outlining the terms of service. Although they require time and attention to create, the benefits far outweigh the negatives, and they are a worthy investment.